Hi everyone, welcome. I am Alvaro Santos, professor at Georgetown Law and faculty director of the Center for the Advancement of the Rule of Law in the Americas, CAROLA. I'm delighted to welcome you all to the first Career Paths session of our fall series, The Americas in Times of COVID-19. This series has 5 modules addressing topics ranging from international investment law, trade, labor, immigration, and business and human rights. We started our first module on international investment law this week with a webinar on Tuesday titled Shaping Investor-State Arbitration in a COVID-19 World. And today we'll hear from panelists who have practiced in the field of international investment and international commercial arbitration. So I want to thank our speakers for joining us today. We're really honored to welcome such a wonderful group of speakers. And I'm going to introduce them in the order that they will speak. This will be a session where we're going to follow a more conversational format. And so I will ask questions and then turn to them to offer their views and share their insights in answering those questions. The goal of the career path sessions is to present students and recent law graduates and practicing lawyers with different perspectives, whether the perspective is public or private or non-profit or academic, in a substantive field of the legal profession. We would like aspiring lawyers to appreciate how exciting and varied and sometimes non-linear law careers could be. And so we have asked these speakers to share their experience and trajectory in the field, share their insights and also their advice for those who are entering practice. All right, let me just say also at the end of these questions and conversation with the speakers, we're gonna leave half an hour for participants in the audience to ask questions. So if you have a question, please use the function in Zoom to raise your hand and I'll be able to call on you. You could then say your name, affiliation, and ask our speakers or either a general question or a question directed to a specific speaker. All right, so let me now introduce our panelists. We have with us Anne-Marie Whitesell, who is professor and faculty director of the program on international arbitration and dispute resolution at Georgetown Law. Thank you for joining us today, Anne-Marie. We have then Borsu Sabahi, who is partner in the international arbitration group of Curtis, Mallet, Prevost, Colt, and Mossel here in Washington, D.C. Third, we have Alvaro Galindo, who is international legal consultant advising on complex international arbitration matters, particularly those involving Latin American jurisdictions. And he's also an adjunct professor at Georgetown Law. And last but not least, we have with us Daniel Uribe, who is a program officer of the Sustainable Development, Climate Change, and Gender Program at the South Center in Geneva. So we're going to start with the first question, which is asking our speakers to tell us what their current job is and the kind of work or projects that they are currently engaged in. This is also an opportunity for us to learn a bit more about their bios and their trajectories. As you saw, my introduction was very succinct, but because I want you to hear from them what is it that they do and how they've come this way. So let me ask first Anne-Marie to answer this question.
Thank you, Alvaro, for organizing this session today. It's a pleasure to be with everyone and to speak about my favorite topic, which is international arbitration. As Alvaro has said, I am a professor at Georgetown, and I am the faculty director for the program on international arbitration and dispute resolution. It's an important program at Georgetown. We have a certificate in the field that many students choose to study. And we have more than 50 courses that are in that certificate program. So it is, for Georgetown, again, an important field. Now, in addition to my teaching at Georgetown, I'm also the director of the Alternative Dispute Resolution Center at the International Law Institute in Washington. I am also on the board of directors of several arbitration institutions, including the ICC's New York branch and an arbitration center in Canada called Arbitration Place. In addition, I act as an arbitrator, mainly in international commercial disputes. And I've also acted as an expert on international arbitration in front of US courts. So that's what keeps me busy.
Thank you very much, Anne-Marie. Let me turn to Borsu to learn more about what you are currently doing, Borsu.
Thank you. Thank you very much for the invitation, Alvaro. It's a great pleasure to be here with everyone. And I am currently a partner at the law firm of Curtis Mallet, Prevost, Colt and Mosley LLP. This is a international law firm. We are not too big, but we are present in a number of countries. And that has provided me an opportunity to be involved in a number of very interesting international arbitration cases. I primarily practice investor-state arbitration under investment treaties. From time to time, I do some commercial arbitration, but bulk of the practice really treaty arbitration. During the last maybe 15 years, I have worked on more than 30 exit and non-exit treaty cases, and in a variety of industrial sectors. I would say maybe about 40% of what I have been doing has been in the oil and gas industry, but I have done also work in the construction, telecommunication, gaming, and disputes involving tax matters and a number of other sectors, logistics, things like that, which has been quite interesting. Every case has been very interesting. And in addition to handling cases, I teach as an adjunct at Georgetown, a seminar on investor-state arbitration. I love it. Every spring I do one seminar, and I always look forward to see the students coming in. I think one of the very important things here to meet new people and get inspired by getting to know each other. I also am a co-director of the International Law Institute's Investment Law Center. International Law Institute is a nonprofit organization in DC. It used to be part of Georgetown. Today is an independent entity. And what I do is with my co-director, Mr. Ian Laird, we set up training programs on ISDS, investor-state arbitration, which are mainly for government officials that come from developing countries, but they're open to everyone. So that pretty much sums up the main activities that I do. Thank you.
Wonderful. Thank you, Borsu. So let me now give the mic to Alvaro Galindo.
Thank you, Alvaro. I hope you all can see me and hear me. I am away from my home at this point, so my connection may be broken at some point. I hope it will work fine. Currently, I'm an adjunct professor at Georgetown University Law Center. I teach a course on international investment arbitration. Basically, it's a thematic type of course with issues that are relevant and that are current in the international investment law arena. I work as international counsel representing sovereign states and state-owned entities in international arbitration, both commercial and investment arbitration. And that's what I have been doing for the last 20 years in my career. I used to work for a law firm here in Washington, DC. I left the law firm and I am today practicing as a consultant, kind of a freelance consultant for law firms and states. I also practice as an arbitrator. I'm involved with some regional arbitration centers in Latin America, and I'm a member of the International Chamber of Commerce in the International Court of Arbitration of the ICC. I'm also a member of the ICC Ecuador chapter, and I currently direct a task force for the reform of the arbitration law of Ecuador. We're trying to renovate and trying to bring the new trends to international arbitration into Ecuador's legislation. And also, it is important for me to mention something that Borzu already mentioned, and it's that I'm always looking forward to meet new students at Georgetown during my course. It's always exciting, engaging, and of course, we always try to put together a course that is attractive and interesting for the students. Thank you, Alvaro.
Thank you, Alvaro. I think your sound was cracking a little bit at the end, but we got the gist of it in terms of the excitement of teaching and how you look forward to working with students. Thank you for that. And then let me turn.
Thank you.
Hello, Alvaro. Thank you very much. I hope everything is working because it was a little bit cut at the beginning. I hope it's my... Thank you very much again for Georgetown for this opportunity. I see that there is an amazing panel. So I'm an Ecuadorian lawyer as well as Alvaro. I used to work for the... I'm coming more from a public law perspective. I used to work for the Ministry of Foreign Affairs and also for the Constitutional Court of Ecuador. Then I had the opportunity to travel to Geneva to make my LLM in international law with its economic law stream. And then I had the opportunity to work in the South Center. The South Center is an intergovernmental organization. It's composed of 54 developing countries. It is an intergovernmental organization composed by and for developing countries. As such, we work as an intergovernmental think tank in which we support the state's negotiations at the international level, particularly in economic institutions. For example, the WTO, UNCTAD in Geneva. And we also follow up certain negotiations concerning the reform of international investment agreements, the negotiation of a legally binding instrument on business and human rights, for example, and some other issues related to international policy making. On that subject, what we do is that we have two streams. One is research and analysis of thematic issues. for supporting negotiations at the international level. But we also offer policy advice to intergovernmental groups for example, the G77, the Group of 77 and China, or the non-aligned movement countries. In that perspective, normally what we do is that we conduct, we serve as a forum for trying to reach agreement among developing countries for particular negotiations, but we also offer the possibility of supporting their position and finding certain solutions for the problems they are facing. So we are based in Geneva. The agreement was signed in 1995. So this year we are actually having our 25th anniversary. So we know that the South Center has been helping developing countries for almost 25 years. Thank you very much, Alvaro.
Thank you. So this gives you a sense of the range of practice that our speakers bring to the table, academic, but also private, public, non-profit. And so it would be really interesting to now ask the speakers to give us a sense from that perspective in which you work. What are some of the most exciting challenges or changes in the field that you would like us to learn about or to pay attention to? So from all this very rich work that you're doing, you think we should be focusing on, or what aspects would you like to highlight for the audience? And this could be, new developments in the practice, or something that you think is just ready for reform, or perhaps a problem that you think is underappreciated that you'd like to highlight, or a new idea that you think is promising or exciting. So let me turn now to Anne-Marie.
Thank you, Alvaro. So I will speak mostly from the commercial arbitration perspective, because that's where most of my background has been, and that's the area I mostly focus on. I would say that the challenge is the changes that are taking place in the practice of international arbitration and how the world is responding to those changes. And if we look at, for example, the types of cases that are going to international arbitration, what we see is the increasing complexity of those cases, the complexity not only of the subject matters, but of the parties that are involved. So we see more and more multi-party cases. We have now class action cases, which are not accepted in all jurisdictions around the world. We have problems of non-signatories who are being pulled into arbitrations and jurisdictional objections. So the cases just on a procedural level have become so much more complex. And I think for arbitration to be able to continue to offer solutions on an international level, it has to deal with those complexities the way state courts are able to deal with the fact of having multi-parties, class actions, et cetera. So we're definitely seeing that change. The role of states, even on the commercial side, more and more state parties are using commercial arbitration, and I'll leave my colleagues to talk about the changes in investment arbitration, but what you see is a movement from investment arbitration in some cases to using commercial arbitration by states. And that, again, changes the nature of the practice. There have always been states in international commercial arbitration, but now there's an increasing number of state parties. And I would say, of course, diversity, which everyone is talking about. It is very important for international arbitration for it to remain credible as a dispute resolution system. But when I speak about diversity, I don't mean, just gender diversity, racial diversity. I mean truly international diversity, because for international arbitration to be truly accepted worldwide, it has to reach out to all parts of the world, and participants have to be acting on all levels as arbitrators, as counsel, as experts, et cetera. So I think that's an enormous challenge for international arbitration today. And then I guess finally, the challenge that we all know very much about that we see today is technology. Because of course, with this pandemic, it has very strongly affected the way international arbitration is being practiced. And we are finding solutions. We are holding hearings online. We are holding meetings, of course, online. Technology is becoming a way of life, but what that will do to the practice of arbitration afterwards, when hopefully people will be able to be back together again, how much technology will continue to be used, I think that's going to be very interesting for the way arbitration is practiced.
Thank you, Anne-Marie. And on the question of technology, I would like to encourage all our participants today, if they are able to turn on their videos so that we can feel, you know, that we see you and that we are talking to you. If that's not possible, which sometimes it isn't, that's okay. But if you are able to, please do so, so that, you know, the speakers can see you as well. Thank you. So now let me turn to Borsu with the same question.
Thank you, Alvaro. I think I would echo some of the points that Anne-Marie raised regarding the increasing complexity in the field of investor-state arbitration. We have similar issues of right now class action claims. My colleagues and I, we are acting for some sovereigns in very, very large claims or multi-claimants. So there are needed solutions are needed there, definitely. And in terms of other issues, I think I would like to invite the audience to look into the work of the Ancestral Working Group 3. Because Ancestral Working Group 3, the reports that it has been preparing during the last 2-3 years, has summarized the concerns of the international community with the ISDS system. And right now, they're at the stage of finding solutions. And I'm part of one of the delegations of the International Law Institute to the Working Group 3. I know Alvaro is there, so he's probably going to share his views there. But my sense is that, for example, they are devising an advisory center for developing countries. That's an interesting development. There has been recently a code of conduct for arbitrators. That's very interesting. And these are open really for review. Right now, they're also working on a appellate mechanism for the ISDS to essentially address all the inconsistent awards and decisions that are out there. And we have had to deal with it. And as many of you may know, there has been a backlash to this system. So developments that on Citral, they're probably very exciting. And frankly, there are so many cases and issues out there that it's difficult to keep track of them. I try to kind of confine myself to that. One of the topics, though, which is very close to my heart, and that was the subject matter of also my dissertation at Georgetown, is the issue of damages, that how to assess damages. We have seen in the last several years that there are multi-billion-dollar damages awards being rendered against sovereigns. We have the UCOS case, 50 billion. Then a couple of years ago, last year, we had Titian versus Pakistan, 6 billion. There was a case, PNID versus Nigeria, 9 billion. So these states, they raised concerns about assessment of damages. And that's, Ancestral Secretariat is preparing a report on that in collaboration with ICA. That's an interesting subject also to focus on. And to finish my coverage of this, pandemic has raised a lot of issues. Anne-Marie alluded to them, and we have a similar issue in the private practice right now. All of our submissions have to be electronically, or we have virtual hearing, virtual cross-examinations, and all of these raised new challenges and opportunities. I think we have all learned how to operate remotely, how to travel less. And I think that has been very interesting. And my guess is that in the future, some of these changes will stay with us. Thank you.
Thank you, Borsu. So let me now turn to Alvaro Galindo.
Thank you, Alvaro. Can you hear me well?
Yes.
Perfect. Thank you. Well, I will add some points on the challenges that our field is facing, particularly related to international investment arbitration. Some of those challenges were already pointed out by Borsu and Marie. I think because of the COVID-19 pandemic, the new challenges are related to the possibility of we adapting to the new technologies in our field. Basically, everything is working through virtual hearings. For example, the evidence, when you talk about preparing a witness, which is thousands of miles away from your place of work, and you have to prepare the witness, the expert, through virtual meetings, and everything that is related to that preparation is very different than what we were used to doing when we were able to do it in person. Of course, this brings new challenges to lawyers, practitioners all over the world. I think the adaptation for those younger lawyers is going to work in their advantage because of how they were prepared for many years in working through technology, which is very familiar basically to everyone today. But that's not the case for those who are not that young and have to adapt to this new reality. Of course, something that was already mentioned in terms of the macro policies that are happening today is the reform to the investor-state dispute settlement process, and in general to everything that is related to the protection of foreign investment through international treaties. As most of you may have heard and know, there is a very advanced process today of the reform that is taking place, the discussions that are taking place within the United Nations International Trade Law Commission, UNCITRAL, which is meeting in few weeks. It's going to be virtual through more than 100 state delegates and private sector delegates and civil society delegates participating very actively to the reform of the ISDS, Investor-State Dispute Settlement System. Both, I think, within the procedural rules and some issues that are going to impact the substantive standards as well, even though that's still a work in process. That's something that is going to happen I would imagine, a couple of years, the result of those discussions within UNCITRAL. Of course, there are other discussions in more, I would say, less universal, but more regional settings in Asia, North America, Latin America, Africa, of course. Those different regions are having their own discussions on reforms and how that's going to impact the multilateral level discussions. So I think those are the challenges today, and somehow the new developments related to the technology. Thank you, Alvaro.
Thank you. And now let me turn to Daniel Uribe.
Thank you very much, Alvaro. So I see that the majority of issues and challenges have already been raised before by the other panelists, and I must agree with almost all of them. I think that an international level, at the multilateral level, the negotiations in UNCITRAL Working Group 3, which are focused more or less only on in procedural issues, have been looking at the issue of consistency and clarity, But I think that there are certain other elements which are important to discuss. For example, the idea of diversity, not only on how tribunals are composed, but also which are the lawyers who are representing states all the time, and how we can bring that kind of discussion and capacity building to local firms. Being local firms part of that process will allow, for example, to cost being not so high for states, and therefore allowing also more or less a localization of those processes at national or regional level. That also brings me to the idea of something that also was mentioning, the issue of damages, how damages are assessed, the linkages with the principle of contributory fault, which more or less are always raised by states, but they are not consistent with certain other obligations that states have to face at international level. For example, issues of environment, human rights, labor, or social protection. This is also linked with other processes which are now being discussed at the international level, and that former Minister of Foreign Affairs, Maria Fernanda Espinosa, brought in the last meeting, on the last discussion that CAROLA had on Monday, which was basically how to link all the issues of investment, of trade, and financial issues with respect to human rights and environment, for example. Now we are facing one of the worst calamities that the world has faced, and we are seeing that the fragility of global value chains, for example, has brought the economy of the world to its knees, and that has to be, and it's linked directly with the protection, with social protection, with labor protection, and with human rights. So there is also a need to discuss reform of investment agreements, not only on the procedural level, but at the substantive level. And some of those discussions are completely linked to, for example, the discussion of the legally binding instrument on business and human rights, which is being discussed in the Human Rights Council, with the global compact on environment, which is discussed in the General Assembly in the United Nations. So that kind of linkages and the discussion, for example, on systematic integration of international law with respect to trade and investment agreements are elements that need to be discussed and must be discussed. We see that more or less those issues are being brought at the regional level. We know that the African Union, for example, is discussing those particular issues, but they are still facing a lot of pressure by other economic powers, for example, to avoid establishing binding obligations of investors in international agreements. So that kind of elements need more of a discussion. And coming into the issue of the COVID-19, for example, we have been facing, as rightly pointed out by Anne-Marie, Borsu, and by Alvaro, we are facing now technology gap and that technology divide, which is clearly stated for developing countries. There are a number of developing countries which are not able to participate in the virtual audiences because they have no infrastructure to do so. We have a Bolivian delegate was explaining the anecdote that they are not able to defend themselves in a particular case, although they have asked or requested for suspension, because they are not able to go and look for evidence because all the ministers are closed. But there is no idea of what is happening at the ground. So I think that linkage between tribunals in Washington, tribunals in The Hague, to what is happening on the ground in countries which are facing these arbitrations is necessary to build up what we are calling localization and regionalization of international investment arbitration. So we are looking at those as some challenges that the South Center is working on. It's also advising some to developing countries and actively participating in working group, non-central working group 3. Just another element which I think I would like to very much to talk with Anne-Marie is the linkages, for example, of discussions happening in working group 2, which is looking at commercial arbitration, with working group 3, particularly, for example, the rules on expedite arbitration that they have been discussing, how they are going to be linked to discussions on costs and also on timing in working group 3. So those elements are there and we are facing those challenges. They are enormous. There are a lot of challenges, but I think that we can work together to achieve some kind of outcome or objective. Thank you very much.
Thank you very much, Daniel. I hope our participants can see the range of issues that have been put on the table by these different perspectives, right? So there's a lot of reference to the problems that have been identified with the international investment law system, particularly the investor state dispute settlement system that have already been addressed or tackled in some ways by the UNCITRAL group number 3, but Daniel is bringing a set of issues that are not within the focus of that group that are highly relevant and that have to do with substantive issues about how do we think about investment, what's the connection between investment and sustainable development, how do we think about the behavior of investors and the type of investment, what type of obligations there should be. So these are all sets of a host of other issues that are important, and I hear Daniela's pushing them to be considered also in the reform agenda. So this connects this discussion very much with some of the issues that came up on Tuesday with the discussion about shaping international investor-state dispute settlement. But the array of issues that you've brought up is really rich in terms of the diversity of the arbitrators, the possibility of creating local capacity for states, the possibility of lowering down costs for fees, as well as the proposals for how to think about a code of conduct, the issue of valuation of damages. So there's just a really rich catalog of issues. I'm very happy that all of this has come up because it gives the students a sense of the number of exciting both issues and also challenges that they could work on, including, of course, the question of technology that several of you brought up. All right, so let me now move to the third question. And here, this will turn a little bit more personal in terms of the reflection of your own career. So you've had different opportunities, you come from a different perspective. And so I think it'd be helpful for the participants to hear a bit more about your trajectory, and particularly sort of insights or lessons that you've gathered along the way. So you're at different stages of your career. I know that students and young lawyers, when they're starting, they're a bit anxious about the choices they're making initially and how that might determine, the success of their careers. And so I think it'd be very useful to hear from you about what you learned from, your own experience and what you can share with the audience. So let me turn to Anne-Marie again.
Thank you, Alvaro. So I think looking at how my career has developed and speaking to students in particular, I guess it is that you can never plan everything. I started out with doing my studies in a US law school and went to work in New York for a large US law firm, but I French background, and so I had never heard of international arbitration. And at my time, because I'm quite old, we did not study international arbitration in law school. It was something that was happening, but really not being studied at the time. And so I landed in New York, and they had an international arbitration, which they needed French for. So they pulled me into this, and that's how I started working in international arbitration. But it was not at all because I had studied it and wanted to work in that field. And from that, so I worked in New York. I ended up moving to work for another large law firm in Paris on the French side. And from there, I moved to academics, and I was teaching at the university in Paris for several years while I did my French doctorate. So I became a French lawyer as well. And from there, when I thought I would stay forever as an academic, the International Court of Arbitration came, and I moved to this arbitral institution. And so at the ICC in Paris, I Started as a counsel, one of the lawyers in charge of the team, then became the Deputy Secretary General, and then became the Secretary General by the end of my stay there. And so there I had the institutional perspective. Of course, the ICC, which handles the most commercial arbitration, international commercial arbitration cases perhaps in the world, allowed me to really gain a different perspective. All right, so from the ICC, then I had to move back to the US. And so I moved back to a law firm. I went back to private practice, where I was acting as arbitrator as well. And from that private practice, I moved back to Georgetown, back to the academic side. So when I talk about international arbitration, I always tell my students, I can truly say I have the perspective of an academic, an institutional person, practicing lawyer as counsel, and an arbitrator as well. But again, none of that was planned. It just kind of happened to, I was the person in the right place at the right time. But I must say that from the first time in New York, I started working on international arbitration. It became a passion. And so I knew that was the field that I did want to stay working in.
Thank you so much. Okay, so let me now turn to Borsu.
Thank you. My beginning of my involvement in arbitration is not dissimilar to what Anne-Marie said, but coming from a completely different background, because I came to Georgetown with a master's in public international law from University of Tehran, and I did an LLM. I thought I'm going to do international trade. Nobody hired me upon graduation. I sent an application to WTO appellate body. I got the rejection. It was good enough. I thought they acknowledged my existence. And so I did one course on commercial arbitration, but it was not my thing. I mean, I just had no idea. So, and it was right after September 11 when graduated. So it was not a particularly good time, particularly with a guy with an Iranian background looking for a job in the US, applying to American firms. It was pretty disappointing to go to ISIP. All of my classmates had all sorts of offers. I had nothing, zero. But then that brought me to the ILI. One of my professors, Professor Wallace, I went to advise. I said, well, we do interesting things here. Why don't you come here? So I did some research for him in the summer. And on that was a time that the Loven versus United States, one of the most famous or infamous, depending on your point of view, early NAFTA cases against the United States, was fully briefed. Just the award was going to be rendered. And Professor Wallace was writing a paper on that with a lot of placeholders for things from the award. I worked on that the whole summer. At the end of the summer, I thought, this is what I want to do for a career. So the question, how am I going to do it? And then I did more research, etc. I reapplied to Georgetown for an SJD, and I got admission. I wrote about a law of damages. That was my SJD under supervision of Professor Wallace, and gradually deepened my knowledge in the field of investor-state arbitration. Along the way, I did a stage at ICC. That's where Anne-Marie was Secretary General at the time. So it was nice to be there. I'm sure Anne-Marie doesn't remember me. I was sitting behind the room and taking notes like all other stagiaires. And that brought me back. When I came back, soon I found my first law firm, American law firm job at the law firm of Fulbright and Jaworski, which later merged with Norton Rose. Right now is Norton Rose Fulbright. Over there, I had a chance to work on my first exit cases, some commercial arbitration cases. I was there for 6-7 years. And after that, I moved to Curtis Mallet, where we work only for sovereigns. The reason that I moved to Curtis was I just wanted to essentially do more sovereign work and more treaty work. We had a large cases in Fulbright on commercial cases, but I thought I need to, and that was also a lesson, you know, in this field. I think you have to follow the work where the work is. But in the meantime, beginning of my career, it was something was very simple. I just pretty much wanted to do something related to commercial law, but I had no idea that arbitration is. I mean, if I had got a trade job, I would have gone with it. Probably I would have been a trade lawyer. But I'm very happy where I am right now with the. Thank you.
Thank you, Borso. Let me now turn to Alvaro Galindo. Alvaro, are you on? Okay, so while he reconnects, let me turn to Daniel.
Thank you very much, Alvaro. So we wait for Alvaro, but so if all of the panelists have so much of a rich background. In my case, I'm a young lawyer. I wouldn't say a really young lawyer, as some of the faces I see in the camera. But I think that in my case, well, I'm an Ecuadorian lawyer. In Ecuador, international law is a subject, but it's not the most important subject. You won't see international law as the topic that you want to follow. Everything is more related to corporate law, which I was not a fan of. So I tried to follow my instinct and more or less focus on human rights. So I had the opportunity to study or more or less focus more on human rights. I had the opportunity to participate in the American College of Law moot court competition, which gave me a little bit more of a broad idea of international law and international human rights law, and that allowed me to understand a little bit of how things move ahead. After that, my first practical and work experience I had with international law was in the Ministry of Foreign Affairs. I worked for the Refugee Division, where I had the opportunity to hear cases from refugees coming to Ecuador, particularly from Colombia, the neighboring country. And it was my first more or less practical application of international law at the domestic level. So I had the opportunity to look at international standards, look at how compare domestic law with other domestic law around, see how other treaties are being applied at the international level. So it was a really, I would say, a really, really enriching experience. After that, I decided that I wanted to practice a little bit more of domestic law. So I turned to constitutional law, and I worked for the Constitutional Court of Ecuador. There I had the opportunity of getting to know, so it is a rich experience. You had different kind of law cases coming to you. You have corporate cases coming to you. You have family cases coming to you, criminal cases coming to you, but also you had the opportunity to review some kind of cases which are international treaties. So you know that for an international treaty to be applicable, you have to more or less do constitutional control and look if that international treaty, which is being signed by the executive or legislative, depending on the country, is actually applicable in the country or adequate to the constitutional legal adequacy in the country. So at that opportunity, I had the chance to start doing a constitutional control of international investment agreements. It was at a time in which Ecuador was also reviewing international agreements, looking particularly at the possibility of terminating them because they were not going or fulfilling domestic objectives of development. So it was an enriching experience. After that, I moved to Geneva to pursue my LLM in international law. I was following also the idea of continuing building my background on human rights, but I had the opportunity to work for the International Commission of Jurists with a Peruvian lawyer, Carlos Lopez, who is more or less practicing, well, he's looking particularly at the issue of business and human rights. And when I was doing that research, I understood that if you don't know corporate law, and if you don't know investment law, and if you don't know trade law, it's impossible for you to speak about business and human rights. You need that background to start looking at the issue and looking how you can interlink those issues. So from my idea of just working on human rights, I tend to understand, and I knew that it was important for me to also understand other subjects of international law and also domestic law. So that more or less brings me to the idea of studying international economic law. and focusing particularly on investment agreements. During that, my LLM, I came to know, because of research, I came to know of the South Center as the Intergovernmental Organization of Developing Countries. So once I finished that, I had the opportunity to speak with some people in the South Center. That was also a huge option in Geneva, because I was in the place where the negotiations were happening. So I had the opportunity to speak with some people here. I started a visiting research position. And then I moved to become a research and then a program officer. So now that I am a program officer, I have a more active role in looking at these issues of deciding what they want to do as a research and following some of the negotiations in the international sphere. So I think that's my experience. As well, I have to say I have an enriching experience. So I don't have the enriching experience that Professor Whitesell has or that Borsu have. But it has been a really, really interesting experience for me. Thank you very much.
Thank you, Daniel. Let me check in with Alvaro and see if he was able to rejoin us.
Can you hear me, Alvaro?
Yes.
Okay. Basically, my career is, as Alvaro mentioned before, type of a non-linear law career. When I was finishing my law school in the Pontificia Universidad Católica del Ecuador, I was doing my thesis on international environmental law, but I had an invitation to visit the arbitration center of the Chamber of Commerce of Bogota in Colombia, and I was able to be present during an arbitration hearing that was taking place during that visit. And when I came back to Ecuador, to Quito, I basically switched from my thesis on environmental law to arbitration law. And I ended up writing the proposal for the reform of the arbitration law of Ecuador. When I graduated from law school, I worked for an NGO that was leading the discussions for the reform of the arbitration law in Ecuador. And I was the coordinator of a task force in 1995, 1996 for the new arbitration law of Ecuador that came into effect in May 1997. That's still the law of Ecuador that entered into force in September 3rd, 1997. It's the current law of arbitration. And as I said before, currently I'm working with the task force of the International Chamber of Commerce chapter of Ecuador for presenting a new arbitration law, particularly for international arbitration in Ecuador. Then when I finished that work, I started working in a university, a private university in Ecuador. I was the vice dean of the law school at that university. And in 2001, I came to the United States, to Georgetown University for my LLM. That's when I met my dear friend Borsu, who was the president of the Students Association at that time. And then I stayed after finishing my LLM with ICSID for about a year, working as a consultant in the International Center for Settlement of Investment Dispute in the World Bank. And then I moved back to Ecuador. I started working as an outside counsel for the representation of Ecuador before international arbitration tribunals. Then in 2008, I joined the Attorney General's Office of Ecuador as a director of the International Arbitration Unit. And I stayed there until 2011. And then I received an invitation from Deckard, a U.S. law firm, to join the law firm in Washington. And that's when I happened to meet Anne-Marie Whitesell, who was at that time with Deckard. We worked together for a few years until she made the wise decision to go to Georgetown to be the director of the International Arbitration Program for the good of all of us, of course. Then a few months ago, I moved from Decker. As I said, I'm in my private practice and as arbitrator as well. So that's basically my experience, Alvaro.
Thank you all. Very rich experiences, and one of the things that I noticed, and sometimes this has occurred to me when I talk to people or when I hear the stories of people's careers, how sometimes they just stumbled into the practice that they're now, but in that accident, there's always a story of a spark that was produced and discovery of something you liked or a passion that you followed, right? Something that was kindled, and then you discover, oh, this could be actually what I do. And so something I really appreciated from all of your stories was the way in which that passion, and no doubt a lot of dedication and work, led you to these different places, doing something that you liked, and then, you know, along the way you had the opportunity to do to experience private practice in a law firm, or a work in an institution, or academia, or government. Some of you have actually kind of gather experience in all of these areas, right? And really round up your perspective and your practice. But I wanted to point that out, the way in which many of you faced adversity and rejections, which, you know, often can be quite humbling, and nevertheless you managed with resilience to overcome them. And it was something that was noticeable was the way in which that passion, or that spark that basically you discover helped you to do that. And so I thought that was really interesting. And also, this is a field, obviously, that calls for international, sort of an international perspective, but all of you have a background that it's also related to another country, whether it's France or Ecuador or Iran. You have also brought that to your practice, right? So you're lawyers and practitioners in the US, but also more generally in the international field. So all of that, I think it's really useful to know. So let me now finally turn to the last question. And since I want to give as much time as possible to participants, I'll ask you to be very brief, because just the participants will have a chance to ask you more questions directly. But what advice would you offer to a recent graduate interested in this practice area? So if you can sum up, you know, a kernel or a pearl of advice that you think, oh, this would be helpful, what would that be? So let me turn to Anne-Marie.
So Alvaro, in the interest of time, to speak very briefly, I'd say if you want to be an arbitration lawyer, the first thing you need to do is first be a good lawyer. And that means get the basic skills of lawyering, learn to be an advocate, learn advocacy skills, writing skills, and you will learn the specifics of arbitration later. Again, not to say you won't learn them in courses at the law school, etc. But the most important thing when you are in the practice, when you see lawyers in front of you, etc., the important thing is that they're good lawyers before they become good arbitration lawyers. So I'd say that's the starting point for all students. Work on those basic skills. And then the second thing is know the market where you are looking, because when you want to be hired somewhere, different cultures, different markets react differently to new lawyers trying to enter. So when you, in the US, will say to people that I want to be an arbitration lawyer, there are very few arbitration teams here that are big enough to take lawyers just to do arbitration. So you have to present yourself differently than if you were on a European market where you have very well-developed arbitration teams. So that's a question of, again, educating yourself as to where you're looking and how you approach that market. And then the other thing I would say is think outside of the box. Don't do what everyone else is doing, which is just interviewing with large law firms. as you saw from everyone this morning, you can enter this field from many different angles. And so thinking about institutions, thinking about other types of opportunity, organizations, international organizations, et cetera, people do move into this field from other places. And the last point is, you know, if you do want to work in this field, you do need, as you have said, to be able to think outside, again, of your own culture and background, and to adopt an international perspective. And that's what truly, I think, distinguishes the great arbitration lawyers from just the ordinary arbitration lawyers. They are the people that are able to put themselves in the shoes of the other person and see things from their perspective.
Wonderful. Thank you, Anne-Marie. Let me turn to Borsu.
Yes, well, Anne-Marie sums it up, so it's tough to add to that. I emphasize being a good lawyer. I think work, particularly if you're a foreign lawyer, is what I noticed in my career going to big firms was, it was essentially, I was competing with American trained lawyers whose English was better than me. And then so I just had to show that I'm very good at that. For arbitration, knowing languages is important. If you know a second language, French, Spanish, etc., that's great. If you don't know, it's possible. I don't know. I mean, I know only Farsi, and there are pretty much no Farsi conducted arbitration. So the second route to that is knowledge. Build up knowledge. There is a market for that. If you're at the level that you like to do a PhD or study more or write more papers, etc., the firms have an appetite to absorb people who know their international law and cases and things. So that's valuable. Other than that, I think keep an open eye, talk to the people, and talk to various opportunities, clerkships, being research assistant to professors. You know, the skills of lawyering in arbitrations, those skills, you can learn them in all of these different settings. If you are a research assistant to a good professor, clerk to a big professor, you are in an arbitral institution, and you can learn them. You can learn them at some point if your objective is to go to a law practice of some size, specialize in arbitration or not. You can transfer those skills there. I think this is all doable. I leave it at that for now.
Great, thank you.
Yes, Alvaro, thank you. Can you hear me?
Yes.
Good. Well, as Anne-Marie and Borsu already mentioned, I think it's important to be at the right moment, at the right place. One example is something that happened to me some years ago when I finished my master's in Georgetown. I was at that time moving back to Ecuador to keep going with my career, but an opening came out at ICSID just right when the Argentinian crisis was happening, and I was able to be hired at that point because of my language skills, Spanish skills, and working those Argentinian cases at ICSID. So that was an advantage at that point. So languages, as being a bilingual, it's something that in international arbitration practice is very valuable. Of course, the knowledge of substantive law, being trained in civil law, and of course, having background in common law studies was an asset. And I think that's something very important to keep enforcing and trying to develop. Publish. I think it's important to take advantage of all the different publications, Kluger, all these different places where you can publish your articles on different subjects related to international law, international investment law, international arbitration in general. So take advantage of that and try to put yourself on the radar of the international arbitration world. Of course, something that happened to me, and I think it was very important, is civil service. I think those of you who will have an opportunity to work with your governments, that's an important asset. You will be able to confront many difficult issues working in international arbitration, representing your states, state entities, etc. And that, of course, becomes an asset when you try to find work and a job with an international law firm. And of course, be flexible. I think we need to adapt to different times. This is the Darwinian world that we're living. We need to adapt to these new circumstances. Those who adapt to those new circumstances are the ones who will succeed in our profession. Thank you.
Thanks, Alvaro. Let me now turn to Daniel.
Thank you very much, Alvaro. I think that everything was already said. I will try to see if I can find any other advice. What comes to my mind is that try to build a path of what you want for your career. After graduation, see what you want, what you really want to reach. But be flexible on that path. Try to take advantage of every opportunity, even if it is not in front of what you want or you would expect. Because as Alvaro was mentioning, a lot of people find their passion just by accident. So don't say no just because it's not on what you want to do, but just take advantage of that opportunity that can drive you to another kind of experience that you were not expecting or you were not actually considering. But it might be that it's your passion and that you are going to enjoy it. So that's one point. And the other one is that when I became a lawyer, I was thinking of only law firms. Only law firms are going to are the worthwhile of fighting for becoming a lawyer. So I just want to work for a law firm and that's it. While the market for legal expert is quite open. So you have intergovernmental organizations, you have non-profit organizations that are seeking for your kind of experience. So don't close just to the idea of working in a law firm or corporate law. Try to find other options that can drive you to a better experience. The most important thing when you are a young graduate is to earn experience. So I think that's one of my advices. Thanks.
Thank you. Wonderful. All right. So now let's open the floor for questions from the audience. And I'll ask you to raise your hand using the function in Zoom so that I can see you clearly. And if you can say your name and affiliation, that'll be great. So James.
Hi, everyone. Thanks for coming and being at this panel. I'm James Carey. I'm a 3L at Georgetown. I wondered if, sort of going with the theme about what Anne-Marie said about knowing the market, if you could speak on the market sort of we're going into and what you think the arbitration business will look like in the next couple of years, both with the effects of COVID and like the probably imminent global recession that we're going to feel. Thank you.
Who would like to answer that? Anne-Marie, perfect.
Well, I think, James, the good news is that there are going to be lots of disputes. There clearly has been an uprise in the cases that are being submitted at institutions. And I say that unfortunately. I mean, it's not good news that the world is having more disputes, but the fallout from the pandemic clearly is going to lead to more disputes. I think that for young lawyers, the difficulty right now, though, is that the law firms are, and I mean, the people working in law firms can answer this better than I can, but they are slowing down on bringing in new young lawyers just because of the difficultness of the situation. And it's not the best training, of course, for a lawyer, their first job out of law school, to be working virtually rather than to be working directly with lawyers inside an office. So it's a mixed message. There's going to be demand, but it's probably going to take some time until the law firms are back to working, I think, in a more normal way with people able to be together I think for now they're trying to get by with the staffing that they have. Although there are, of course, exceptions, because you hear of the firms that are taking on people, that are starting people working remotely, but you also hear of the firms who have postponed even their clerks and people that they had hired, that they're not bringing them on. So it's hard to generalize. That's why you have to, again, be willing to keep looking, be open, and do your networking.
Next, I have Nicola Soikoy.
Might I add something to Anne-Marie's just from this, before we move to Nicole? I think what Anne-Marie said reflects what's happening in the market right now. At the junior levels, law firms, there is a very slow intake of new talent. But it's not that we have closed our eyes. We're just kind of really trying to get these people. Next summer, essentially, program is away still. I have a feeling that many firms, if by then we are back to normal thing, it's gonna happen. But for the non-traditional entrants, which are kind of a foreign graduate LLMs, you usually don't enter through that anyway. You know, it's just a matter of, so the question is, what are the opportunities, etc. I think just be flexible, invest in yourselves. You know, if you have a paper that you have written is not complete, just finish it, make it publishable, put it out. You know, that things. These are line items on your resumes that's going to keep it busy and keep it full. And as Anne-Marie earlier suggested, think out of the box for non-traditional opportunities. There are a lot of research projects, etc., and these are useful. They would increase your value as a lawyer if you kind of get yourself involved and learn these things. Thank you.
Great. Nicola.
Hi, thank you so much. I'm sorry I don't have my camera on. We have electricity cuts, so I'm using my phone's data and I don't want to use too much. I'm calling in from South Africa. I'm at the University of Witwatersrand School of Law. I just had two quick questions. The first was, in terms of those working as arbitrators, it seems like some people come to it from having worked in human rights or having worked in NGO or for the state, and they almost exclusively represent states. And then others who maybe come from a commercial law background, if they're working as arbitrators, they're almost exclusively representing corporations. Is that true, or are some people kind of doing both? And is the path kind of separate for people wanting to do either? And my second question would be primarily directed at Bozo and Danielle, but also to anyone. If you're advising developing countries on international investment, how do you deal with kind of the ideological challenge? I mean, are you just trying to support them in entering as many BITs as possible? Or are you sometimes saying, you know, perhaps arbitration isn't right for you, or perhaps, you know, you need to negotiate more regulatory space here? So, I mean, there's very conflicting views in terms of the benefits of IIAs in general, and how do you deal with that? Thank you.
Great. So let me turn to our speakers.
I can.
Sure.
I mean, the first question seemed it was framed in a way that it talks about arbitrators. I thought it would make more sense for the council. I don't know. Anne-Marie and Alvaro are much more qualified than me to talk about arbitrators. I give the position, the perspective of council type. You know, I think at least in the investment arbitration market, you will find three categories of firms. Some of them only act for sovereigns. That's my firm, Curtis Malloy. I think there is another firm, Foley-Hoek, that does that. Then there are some firms out there that do primarily claimant work. And then you see, for example, law firms like King and Spalding, etc. They do primarily that. And there is a category in between that they do both sides. And what lies behind these choices, I'm not quite sure. I can talk about our perspective, my first perspective. It just kind of prevents us from having conflicts of interest, particularly issue conflicts. My colleagues and I, we only act for governments, because if you go to an investment arbitration, for example, you have a dispute over interpretation of fair and equitable treatment, and whether it's linked to minimum standard or not, or is it equal to minimum standard, we feel more comfortable to take the sovereign position rather than going to another hearing and changing our position completely, put a claimant hat and say these have nothing to do with each other. It's just a more solid position. And that's how we act. I mean, for others, it may be just not important. But these issues increasingly are under scrutiny, particularly in the ancestral working group 3. In terms of advising developing countries, well, that's a very complex issue. I mean, if you, the chairman of my firm, George Cahill, he has written a lot about these things, and he would tell that you need to terminate all of them. You need to terminate all of them, and because of the flaws, because of the multi-billion-dollar awards that are out there, etc. I don't go that far. I think there is probably value in these treaties, and there are some studies as of 2017 that show that if you have proper treaties in place, they may help to, for example, increase the flow of capital. We all, of course, know that South Africa terminated all of their bids because they didn't see any correlation between the BITs and inflow of capital. But I think properly worded, maybe reformulated bids, etc. There may be one element among many others that could help provide a good, essentially, investment environment. I leave it at that. Thanks.
Thank you, Bor. So this is a fascinating area, and of course, one that's been also debated in academia, right? The connection between bilateral investment treaties and the flow of foreign direct investment, which I think has been quite questioned empirically, but it's an important debate. And I think that your point also relates to a point that Anne-Marie made earlier, which is that even if you terminated your bilateral investment treaties, you might still see arbitration based on contracts from investors between investors and governments, right? So that you would see movement in the international commercial arbitration field, and then that relation, which Anne-Marie sees now increasing, will be important to examine as well. Okay, so we have a queue of speakers. Daniel, if you want to jump in very briefly, that would be great, and then I'll move on to our next question.
Yeah, I'll try to make it really brief. So on the first question, I think that when you're looking at arbitrators, what the states look normally is those with a international public law background, not necessarily human rights or environment, but international public law background, given that what you're looking is the liability of the state. So they don't want to have private commercial arbitrators, but they want to have arbitrators that know international law and know how to apply those principles into the arbitration. So that's why in certain cases you will see that you have that kind of arbitrator pushed by the state. And on the other one, we as South Center, we are not actually pushing for states to sign the majority of agreements. What we actually advise is to look at that linkage that Alvaro was saying. Look at how, if you sign a bilateral agreement, an international bilateral agreement, you have to realize about the linkages that you want to have between the wording of that treaty with respect to your development objectives, as well as to other international obligations that you have as a state. So it's your decision as a state, but then you have to look at this kind of dynamic and integration. Thanks.
Thank you. Let me bring in Sarah Duki, who has had her hand up.
Hi. Thank you all for being here. My question relates to how the pandemic has affected reforms in investment arbitration. Has has the pandemic like highlighted the inequalities among signatories to the extent that it's accelerating these reforms, or have the disputes just grown so much that reforms are now kind of on the back burner, or neither?
Who wants to answer that question, that easy question?
If I may, Alvaro.
Please, Tocayo.
Yes, of course. I think it has impacted the discussions. Actually, UNCITRAL working groups meetings were postponed indefinitely when the pandemic started, even though now we know that the working group 3, where the ISDS reform is taking place, will have its next meeting virtually in few weeks from now. But it does have an impact. With my different contacts in governments, I know that they're struggling to work efficiently to bring their proposals on time before the working group meets in a few weeks, because we all know it's not the same to work virtually with your teams, all split up in different places, in not working together in the same office. So it does have impacted the development of the work of at least the working group I'm familiar with in UNCITRAL. And that would, I think, have an impact at the end of how soon we will see these results of the discussions in different forums that are working in the reform of the international arbitration system, particularly in the investment arbitration system. Thank you.
Great, thanks, Alvaro. I would just add to that that our discussion on Tuesday also was related to this question, and some of our speakers, in fact, all of our speakers, thought that the pandemic provided an opportunity for making an intervention that could then serve to address some of the structural problems of ISDS, right? And so they were proposing a variety of measures that state could take that would prevent claims of investors against states for they've taken during the pandemic. Measures related to public health or economic stimulus, right? So I encourage you to go back, and that session was recorded. So if you're interested in this topic, that'll be a really good session to watch, because speakers provided very concrete legal proposals for how to do a moratorium, for example, on claims, or suspension on claims of investors, or how to terminate treaties, or withdraw the consent to arbitration. So there are a few different measures that have to do with this question of how do we deal with the potential flood of claims at a moment where the states are the most strapped for resources because they're dealing with the pandemic, and that are measures that they needed to take for emergency reasons. Okay, so let me move to, so we have 6 minutes. Move to mine order. Please just remember to say your affiliation, and if you want a specific speaker to
Hello, my name is Mina, and I'm a Georgetown 1L. My question was, I mean, it goes a bit to what Professor Whitesell was saying, but I was wondering if we're particularly interested in a sector, what is the best way to marry that interest in with international arbitration? Or does international arbitration by itself usually mean that you become more of a generalist in terms of the different sectors that are involved?
Great, thanks.
Do you want me to answer, Alvaro?
Go ahead, yes.
Okay, so I mean, I think that there are people in international arbitration that do become specialized in sectors. such as, for example, construction arbitration or oil and gas arbitration or financial sector disputes. So it is very possible, and I think those people are looked to for the large disputes that come in a certain sector. But the more general contract disputes that aren't specifically related to one industry, there you're going to find everyone handling those types of cases. So you can develop a specialization. I think that's a positive. But there are people doing both, specialized arbitrators, and there are even arbitration institutions for specific industries. So that you will see, for example, for financial disputes, there is a specific arbitral institution that's handling those types of disputes, as opposed to, again, the more general contract disputes that are being handled by everyone.
Thank you. Nasli Chichek, and I'm sorry if I'm mispronouncing your name.
Oh, it's okay. Hi, I'm Naz. Can you hear me?
Yes.
Okay, perfect. I'm Naz. I'm pursuing a PhD in international law at Bocconi University in Italy. And I have a question for Borzu and Daniel regarding how the backlash against the ISDS has intensified after the outbreak of the global pandemic. Because as we all know, the ISDS has already been facing considerable backlash from different actors. And although there are many developments underway in order to reform it, in order for these developments to actually materialize into something enforceable, they require multilateral consent, which takes a lot of time to be realized. So what I'm asking is, my presumption is that there is going to be a considerable decrease with the states signing bilateral investment treaties or willing to modify them or make change to them, because even small changes that they are going to make with the treaties will be subject to judicial interpretation or approval afterwards. So what I think is that many developing states, like the ones in Latin America, that have already been pursuing a national adjudication for investment disputes will now be more willing to incentivize, I would say, foreign investors to pursue national remedies for investment disputes.
Okay, so let me turn to Borzu and Daniel.
Sure, I'll be quick. Whether a pandemic definitely has had an impact. There has been some cases, I think I have seen one or two treaty cases that has been triggered by the effect of the pandemic. But there has been by far more cases in courts. So whether pandemic has really intensified backlash against ISDS, I still am yet to see a deluge of cases arising out of pandemics under the treaties. If that comes, maybe yes, but at the moment, I don't think it has really been. Maybe it comes next year or late. I just don't know yet. I think that probably will be the gauge for whether there's going to be a kind of a backlash. We have seen the reactions. I think Columbia Center on Sustainable Development, early on, they said that you have to pause the disputes during the pandemic, which many people essentially said no. I think what is important, if these disputes come, emergency exceptions, etc., in the BITs, those are going to be, again, studied hard, and people will kind of try to figure out whether they apply in this situation. Thanks.
Thank you. And I encourage you, Nas, to look at Tuesday's webinar and the work of the Columbia Center for Sustainable Investment, the work of the International Institute for Sustainable Investment, for Sustainable Development. They've both worked, and also the Harrison Institute at Georgetown. We're doing work with them, but those centers have put proposals, specific proposals about what states could do to suspend those claims and to think about reform in this context.
Okay, thank you.
Alvaro, thanks. Just to add up a little bit, so one of the issues that countries are facing now, if you can take it as a backlash, is that some of the experiences that particularly Latin American and North African countries face during social crisis or economic crisis have actually led to a number of ILDS claims raised against them. So they have that as an assumption of threat. So they believe that the measures that they have taken during this process or during this period might give rise to certain kind of claims or threats in the future. So we are looking at that, and a lot of organizations, as Alvaro was mentioning, including the South Center that is working with the Columbia Center for Sustainable Investment, are looking at ways in which you can consider a suspension of these kind of claims. But there is also the other element that we raised before, which was the idea of claims which are already being heard by tribunals that are not suspended, but countries are not able to defend themselves because of different issues, the technology gap, the lack of possibility of going to your office to look at the document that you were using for defense. So all of those elements are also some of the considerations that states are taking as a mechanism to defend in existing cases. And now I think Alvaro has a little bit more experience on that, but a lot of countries in Latin America are looking at the issue of aftercare procedures, of aftercare measures, and also mediation of other alternative means at the domestic level to try to give an offering to the investors to solve issues at the domestic level rather than just going into international investment arbitration. And this is because some of the issues of cost, for example, cost durations, are concerns which are raised by both states and investors. So these kind of mechanisms are also there to promote the idea of bringing investment into your country or investment flows and giving an opportunity to resolve issues at the domestic level. So Brazil created the Ombudsman Office, for example. In Brazil, they don't have any kind of VITs in place, and they created the Ombudsman Office for investors to try to solve issues before the dispute is actually raised to a dispute level. So those kind of experiences are also shared. Thanks.
Thank you, Daniel. So I'm told that we have a couple of extra minutes, and I'd like to invite the two participants who have questions to ask their questions and direct it towards someone, and then we will close the panel. So I have first Laura and then Tian Yubo.
Hi, I'm a recent graduate from Georgetown Law and now an associate, a litigation associate in a firm in New York City. And I was wondering, like, you guys have all mentioned the importance of jumping at opportunities and exploring different avenues. But I was wondering then, when you're in the position to be applying for a job or looking for a new opportunity, what is the best way to collect all of your experiences and present them in a way that makes sense to somebody who's in a position to hire you?
Great, thank you. So let's keep that question on the table, and then let me go to Tian Yubo.
Hi everyone. My name is Tian Yubo, and I'm from Beijing, China. And right now it's like almost 1. And I'm currently working as a legal specialist at Santos. It's an organization that provide insurance policy to the investors, so the investor can just transfer their risk in the foreign with the investing in a foreign state to the insurance company. So sometimes we take the position of the investor and do arbitration with the state. My question is to pursue, because I'm very interested in what's the differences when you're representing a sovereign. Are there any differences between representing like a private client? And also, I'm also curious because right now I'm working in the insurance company. I'm also curious about that. Arbitration or any dispute resolution is always like the last resource that anyone would do. So if there are any like pre-step that lawyers can help the investor and state?
Great, thank you. So 2 questions. How does one couch one's legal skills when one is thinking about one's options and career opportunities? Laura's question, and then Tenjubo's recent question to Borsu. So who'd like to answer Laura's question?
I can say a few words, Alvaro. Laura, I think, again, when you're looking for new opportunities, you have to think about the person opposite you. Try to find someone that's going to have something in common with you and what you're doing. The worst thing I always tell law students is to send your CV to an HR person. What you need to do is, based on these interests that you have developed, find someone that's going to be more receptive to that, so that you will, again, be able to present what's special about you to someone who will appreciate it. That doesn't answer all of your question, but it's a piece of it.
Thank you. And Borsu.
Thanks to Tianyubo. It's a complicated question. I work in the investment arbitration on this sovereign side. And as I said earlier, in investment treaty arbitrations, we don't switch side because there are a variety of conflicts, essentially different interpretation of the same legal issue. So we do act on some commercial cases for companies. And so in that sense, we may feel free to essentially to act for a smaller company if there is no conflict between the two. I mean, what you're doing, as I understand, goes to really some sort of a risk insurance that the entity for which you work provides. In a lot of large cases that we handle, some foreign investors, they do have some political risk insurance too, that they act, they may also try to kind of go and act upon it. Whether you will need to go get there, sometimes the two parties, they negotiate for years. It may not be necessarily a formal pre-med or some sort of a formal mediation or pre-arbitration things, but they do try to resolve these issues. And oftentimes, though, when a foreign investor sues a government in an investment treaty case, it means that things are not working. More recently, I have seen a trend where a number of foreign investors, in the old days, they were calling that when you bring an investment treaty arbitration, this is the exit strategy. You want to leave the country. But recently, I have seen it that they just use it almost as a threat. During the negotiations, they started treaty arbitration, and that proceeded. And in the side said, no, we're talking, but we want to kind of also pursue our treaty options. So I don't know whether I answered but these are the kind of trends that I have talked and seen, and happy to maybe later to talk about them.
Thank you. Well, so I want to thank our speakers not only for sharing their trajectories and experience, but also for staying a bit longer than what I had asked them to in order to answer our participants' questions. This has been very enjoyable and enriching conversation. So thank you so much to all our speakers, Anne-Marie, Borsu, Alvaro, and Daniel, for joining us today, and for our participants for joining us and engaging with us. we will have our second model on the future of international trade in 2 weeks' time, starting on Tuesday in 2 weeks. So we hope you can join us then. Thanks again, and I want to just take a moment to thank the CAROLA team, our executive director, Lelia Mooney, and our fellow Mario Osorio, and also the Georgetown team that makes this possible, Cara Dobbs from the Centers and Institutes, and Kyle Bernardos from the AV support. Thank you all, and have a good day.
Thank you.
Thank you.
Thank you very much.
Thank you very much. Goodbye.